this is for the first time, my lords, after 75 years, that your lordships would be considering that the privileges with which the residents of Jammu and Kashmir have been deprived of till then, till date, have been conferred. And I make this submission good, that so far, Article 370 function as a detriment between the welfare scheme flowing from the center, the constitutional right flowing from the center, and the residents of Jammu and Kashmir. But second thing, but because of this confusion, whether it is temporary or permanent, there was a kind of a psychological duality which was in the minds of one particular region of our country, though since inception of the constitution, it became part and parcel of inalienable and integral part of India, but there remained a psychological duality, whether induced or otherwise. That, my lord, your lordships would end. Judgment going either way, my lord, that position would end. And third, my lords,
Mr. Solicitor, the first one, can you just in a sentence again formulate it? I somehow missed the first one.
Yes. Lord, your lordships would find at the end
I
of...
don't want to interrupt my learned friend, Malad, but the new volume has been added. 2 new volumes have been added, which were not there before, 2 days ago. I don't know, Malad. I may be wrong. I have no objection, Malad, but I just want to point that out.
It was added with the permission of the court before 6 days.
It was added, that's all I'm saying, Malad. The written submissions are new. I'll not object to any of that because I don't believe in objecting to materials which are relevant for the court.
No, that's
the court told me.
It was permitted, my lord. We mentioned your lordship.
I'm not disputing. You may have mentioned. I'm just saying, Malad. I have still no objection, Malad.
Volume 3 are your submissions, Mr. Solicitor?
What, my lord, your lordship, my lord, the Chief Justice would recall, my lord, what we have done is my submission, the submissions of the learned attorney, and my lord, all our submissions are placed in one volume. Our submissions, my lord, were new and detailed after, my lord, hearing them. And thereafter, my lord, in a chronological order and with continuing pagination, they form part of volume number.
On Monday, when the solicitor mentioned in the morning, you informed us that the list of dates which has been filed by Mr. Sibal.
Yes, that is incorporated.
You're adopting the same list of dates, but where you're adding something,
yes,
you're putting it all together, so we don't have to flip between list of dates.
Written submissions are all new here.
This
Are all new. I'm not disputing. I still am not disputing.
I believe.
I still will not dispute. And I'm just saying, Malad.
Then let's start, my lord, because
I'm only saying, Malad, I was not allowed. That's all. All these are all new. But I don't mind, Malad. We'll answer.
What we had, when he mentioned on Monday morning, I think we asked him whether notice has been given to everybody, and solicitor said yes. At that stage, I told the solicitor, instead of having 5 different list of dates, work on the list of dates which Mr. Sibal has submitted. I'd also mentioned it in the course of the hearing.
That's right, sir.
And in that list of dates, add what you are adding separately so that we know what has been the addition by the Union of India.
Not only that.
All of us have one master list of dates. That becomes much easier.
I don't know. It would have been better if this objection would have been raised. Because let's not, my lord, people are watching, let's not be, my lord, school children like objections, my lord. It was given on that very day at night.
No, it's because the
Not
court
right,
Apart from that,
not
please
informed.
hold your tongue.
Document is created on 24th August, which is today. The PDF says it's created 24 August. So I don't know how it would have been mentioned.
Mr. Prasanna,
Anyway, Malad, I think that we should go on with the hearing. I'm not objecting.
No, let's say.
you object and thereafter you are saying I am not objecting.
Because I was told that I should not be able to add anything. I had only put some just 5 pages.
Whatever is.
Assuming that
your submission also, it would have resulted in many more people.
That's why, Malad, I didn't press it.
I don't think we should go on this.
But even that has been taken note of.
That's all I'm saying.
Gopal Shankar Narayan was here from day one. He could have told us, but my lord, I must make a positive statement. Before we mentioned before your lordships, the previous night, this was placed on record with a service to all. They were aware, and my lord, they knew that this is the master list of dates which all of us on this side will rely upon.
May I clarify? One second. Mr. Solicitor, On your master list of dates, I hope you have maintained the integrity of the original list of dates.
Yes.
Where you want to add something that you have indicated to us in a separate note or separate color or track change.
What I have done is, my lord, I believe at the outset that it seems my list of date contains something, because this first objection appears to be the best point now, after my lord, this list of dates. But leave it at
No, Mr. Solicitor, the reason why we ask you is, when one sits down to dictate the judgment, I hope in the list of dates we will know what is Mr. Sibal's part and what is your part. So long as that is there, it's no difficulty for us.
Come to page 1 of my list of dates.
So long as it is there, we accept your word for it. But so long as your juniors have prepared it in that way, there's no difficulty.
Mr. Sibal, only a minute. Mr. Sibal's submission are incorporated in that general common list of dates in italics in blue color, saying KS means that's the list of dates of Mr. Sibal.
And whatever you wanted to add, you've added in a separate font or whatever. Then there's no difficulty.
Your Lordship's, my lord, judgment is going to be a historical judgment. Is this? A, Lord, after going through, my lord, the facts which we will point out on this side, your Lordships would be satisfied that large number of fundamental rights and other rights will be now conferred upon the residents of Jammu and Kashmir, and they would be fully at par with rest of their brothers and sisters of this country.
Yes.
But number 2,
yes,
because of the ongoing confusion, which according to us there was none, but because of the ongoing confusion whether this provision is temporary or it has become permanent, etc., there was a psychological duality amongst the minds of the residents of Jammu and Kashmir, and that was being taken disadvantage of by, I would say, my lord, interests not inimical to India. That would be settled once and for all, whichever way your lordship decides.
yes.
Now, my lord, I'll take your lordship, my lord. I must, my lord, assure your lordship that yesterday we undertook an exercise that your lordships have been appraised with almost everything, my lord, on facts. But your lordships are specifically not appraised with many things. So, my lord, in my list of dates also, we have, my lord, marked which portions we would not trouble your lordships by reading. So, this is only for one reason, my lord, I am reading this part. My Lord Justice Gawai was pleased to put a question. There was a Praja Sabha constituted, your lordships would recall. And my Lord's question was, what was the composition of the Praja Sabha? Well, that is what is mentioned. Maharaja Hari Singh enacted 1934 Constitution of Jammu and Kashmir. This law established a legislative assembly called Praja Sabha, which was to function under the supremacy of the Maharaja. Lord, answering my Lord Justice Gawai's question, the Praja Sabha was to have 75 members, of which 12 would be officials, 33 elected members, and 30 nominated members. Then, my Lord, rest your lordships can consider skipping, my Lord, and kindly come to, my Lord, 7. Just, my Lord, taking your lordships chronologically, your lordships have seen this provision as well. I am just, my Lord, refreshing your lordship's memory without reading the provision. Lord, this is a part of Government of India Act 1935. Lord, why it has become long, the relevant parts are quoted for your lordship's immediate reference. My lords may not have to go through volume 1, PDF, page so and so, but page numbers are also mentioned, my lord, if your lordship would like to go through. My lord, the purpose of showing this is to, my lord, point out to your lordships, and ultimately I'll assist your lordship with that proposition and 1 or 2 judgments on this. The moment the accession is complete, the sovereignty gets lost. The sovereignty is subsumed with the bigger sovereign.
Yes, sir.
So there is a Privy Council judgment and few other judgments also, Lord, which we'll, Lord, take a little later on. Lord, there is one trivia, Lord, I have just added it. It doesn't make any difference for either of us. But as, my Lord, we attribute the Indian Penal Code to Lord Macaulay, Lord, this entire exercise of 1935 Act was done, my Lord. He was the author virtually of this, my Lord, Sir Samuel Hoare. One of the unsung heroes, my Lord, in the history of Indian partition, but it was he who drafted this. It has no bearing on the main question.
Actually, Mr. Solicitor, you may also read Section 5.
Yes.
Because what is the importance of accession? That Section 5(1) gives us.
Yes. Not the smaller regions which eventually.
The consequence of an accession under the Government of India Act was that then the acceding, they would be united in a federation.
The federation.
The key words really in 5 are united in a federation.
In a federation. So, my lord, that is the first stage of losing sovereignty. The moment you sign accession and it is accepted.
But you'll have to at some stage deal with the argument which they have urged that sovereignty itself has an external component and an internal component.
That
external component was lost, internal sovereignty still remained. That's the
argument, my lord. We are conscious of that. And, my lord, I'll also bear in mind your lordship's very, very pertinent observation that ends may not justify the means. I'll also show to your lordships the means adopted strictly within the constitutional parameters and as per various judgments of your lordship. But that's, my lord, after, my lord, the factual chronology. Lord, this is also crucial. We were, as British India also, our leaders were already negotiating that princely states should also come at par with the provinces, British provinces, which were already under the suzerainty or sovereignty, as the case may be, of the British. Then, my lord, 7th September 1939, Jammu and Kashmir Constitution Act 1939 was issued by Raja Hari Singh. It established a council with a prime minister. Why, my lord, I'm reading this, my lord, I'll just paraphrase this argument. Lord, why I say this? Lord, substantial arguments, my lord, were made that there were no constitutions. Jammu and Kashmir had a special place in the geographical British India because that was the only part which had its own constitution in 39. But that is factually incorrect. There were 62 states which had their own constitutions, whether they are named as constitution or any instrument of governance, internal governance. I'm just trying to show that the argument that Jammu and Kashmir had a special status from the beginning, which continued till date, is factually wrong. The foundation is wrong. And 286 states were in the process of framing that constitution during this period of late 30s, 39 onwards. As a matter of fact, the eminent councils of the day, those days, were, my lord, engaged to help the princely states to draw their constitutions. I'm not going into that detail, that's not relevant, but one of the, my lord, when we researched this, Alladi Krishnaswamy Iyer, who was considered to be one of the top ranking councils, was engaged. His fees were not found to be, the problem was there at that time also. By one state called Rewa in present Uttar Pradesh, I'm sorry, Madhya Pradesh. And therefore, my lord, he was requested not to continue because it was found to be too exorbitant.